record to the cloud. Okay, so is it recording? Are we recording already or no?
Yes, I think so. Let's see.
Yes, we are. Okay. All right. Hi, everyone. And thanks for being here. We're going to go over just a little bit of background. I'm going to just bring us up to speed on where we are with the ERA. Most of the people on here, I'm thinking, are aware of that, what has been happening. But I'm going to just go over that really briefly so that we can get up to speed with where we are now. As everyone is, I'm sure, aware, we've been fighting for the Equal Rights Amendment for over a century now. The first draft of the ERA was introduced into Congress in 1923, the Lucretia Mott Amendment, and then it was changed some in the 40s, and we finally in 1971 passed it in the House. 72 it got passed in the Senate. There's only two requirements for an amendment that needs to pass the U.S. legislature by a 2/3 vote, 2/3%, and then vote, and then it goes to the states for ratification, and it needs to be ratified by 3/4 of the states. We didn't reach that by the time the initial deadline, which we argue is not valid, expired in 1982, and then in 1992, the 27th Amendment was ratified after over 202 years. So then, there were a lot of women that said, we're not honoring this ridiculous 10-year deadline. We're going to get after, this really pretty inconsequential amendment was passed in 1992. So we're going to go ahead and get the other three states. And that actually happened because of the people on this call that really worked and worked and worked to get those last three states. We can thank Equal Means Equal, Wendy Murphy, and Jean Sweeney, and everyone else that has been working for that. We finally got the last three states. It was 2017, we got Nevada. 2019, we got Illinois, and then in 2020, we got the 38th state, which was Virginia. And then the Trump administration unconstitutionally prevented it from being published onto the Constitution. The Biden administration continued that obstruction and even fought it in court. So that then, we put a lot of pressure on him to finally get the archivist to publish, but all he did was make a statement. But after there was tremendous pressure. That's all he finally did. So now we're looking at where we go from here. So we're going to start today with Kamala Lopez, who is I'm going to switch here for a minute, switch my screen to a different one so I can read all the bios for these people. If I can give me a second, boy, I'm on a new computer and this thing kind of drives me crazy. So let me go over here to that. Okay. Kamala Lopez is a founder and president of Equal Means Equal, filmmaker, activist, and president of Heroica Films. Kamala Lopez launched the movement and documentary film Equal Means Equal to educate Americans about the importance of equal rights under federal law for women and complete the ratification of the Equal Rights Amendment to the U.S. Constitution. So take it away, Kamala.
Well, first of all, Carol, I thought that your introduction was so excellent and so succinct. I think that it really will help people that don't know what's going on and stop us from having to repeat a lot of stuff. So, given what Carol explained and the fact that in January of this year, 2025, on January 10th, as Carol mentioned, there was a lot of pressure in the last days of the Biden administration to try and convince him to tell the archivist to publish the ERA. Now, the archivist had already stated that she was refusing to publish. Just on a side note, she is married to somebody that works for the Koch brothers. She clearly thought that by failing to publish, she would endear herself to Donald Trump. But, you know, as history has shown, she was booted pretty soon thereafter. But she refused to publish, which violated her obligation as an archivist, and she took on the role of deciding for the entire population of the United States not to do something that was stated very clearly in Article 5 of the Constitution, which is upon ratification of 3/4 of the states, the amendment shall be adopted. It's not, you know, optional. It's not something that she can decide to do or not do, but that's what happened. And instead of firing her, which is what President Biden should have done, fired her, put in an interim archivist and ordered them to publish, he allowed her to disrespect the millions and millions of, and the majority of the American population that had decided that women, yes, were actually equal and should be treated equally in our Constitution. And then he proceeded to do a very sort of lip service PR move on the 17th of January, which was to come out with a statement that the ERA is in fact the law of the land without giving it any teeth or any enforceability. On January 10th, Equal Means Equal staged a protest at the National Archives along with Katie Hornung's organization, which is called Vote Equality USA. And we had 28 women representing the 28 states dressed as the B'nai Gesserit from Dune, along with 7 activists, independent activists working with Equal Means Equal to take down the 40-feet banners that were hanging from the front of the archives and replace them with ERA banners pressuring Biden to publish. We were able to get the middle banner down and up before we were stopped by the police. 30 people were detained, 7 were arrested, and to date, one of our activists by the name of Adam Eidinger, who was there protesting with his daughter, is now going to trial for what was really a completely non-violent action where nothing was damaged. The property of the archives was replaced within an hour. There was no trespass because it is a national monument, and yet he is going to trial. And it's very interesting to see the type of political prosecution that is being imposed on protesters, certain protesters, while the individuals that stormed the Capitol on January 6th were all given pardons. And so we hope to be able to rally women to support Adam Eidinger's trial, which will take place in October, show up outside the DC federal court and demand that the Equal Rights Amendment be enforced. We are also working with Wendy Murphy, who you are about to hear from, to bring a case that, and Wendy will go into all the details, but essentially one of the main things that the case will do, which is Equal Means Equal versus Donald Trump, is pressure the Supreme Court to state that the ERA is in fact valid, and along with some other things that it does. So we hope that you will support us, equalmeansequal.org, that you will show up for these protests, that you will sign up for our mailing list, because we really need to show the federal government that women are no longer going to tolerate second-class citizenship status. We are seeing a direct attack on our rights, whether it's reproductive rights, birth control, mothers' protective rights, all kinds of things. There is an all-out attack on women. The misogyny is off the charts. And one of the things that the ERA does is sort of put a cork in the dam, as it were, and allow us to fight back with the Constitution under us. So thank you very much. If you have any questions, I'd be happy to answer them after the presenters.
Yeah, thank you so much, Kamala. And let's go then to Wendy Murphy, who will talk to us about this very interesting civil rights case that you're filing on behalf of EME, correct?
Yes, yes, I was delighted to engage EME as the lead plaintiff in this case, which I'll tell you about in a second, because I do think it's important that there's some consistency in all the courts understanding who are the organizations that are actually leading this fight, and how relentless are they. And there's only one organization that has been so relentless. And I don't mean none of you are part of organizations that have been supportive. I'm talking about getting involved in the front lines, irritating people, including people in the courts. And so, yes, I put EME up as my lead plaintiff for this new case that I filed in Massachusetts federal court. So to back up, to just give you the basics, I filed a lawsuit to challenge a federal law as unconstitutional because it discriminates against women. I'll tell you what the law is in a second. But the reason I filed was to create another opportunity for the courts to say, is this discrimination allowed under the Constitution? Because without the ERA, all sorts of discrimination against women are allowed. Some people don't really understand what it is that women experience in the nature of inequality under our Constitution, because they say things to me like, well, what rights do men have that women don't have? And I answer, and I hope many of you also will start saying this back if you get that question, that's the wrong question. It's not what rights do men have that women do not have. It's what laws must, as a constitutional matter, be enforced equally when applied to women. This is an enforcement problem. The answer to that question is none, zero, no laws in this country, no rights, no laws of any kind, from freedom of speech to getting a dog license to rights to privacy. We all know the implications of not having equal privacy rights, and even laws against slavery need not be enforced equally when applied to women. So even though we have a law against slavery in the Constitution, right, it says all persons, doesn't exclude women. The 13th Amendment forbids slavery, doesn't say but women can be enslaved, right? But it's modified by the 14th Amendment, which has an equal protection clause, which means unless that equal protection clause equally protects you for all purposes, all laws, including the 13th Amendment, can be enforced unequally when applied to you. Doesn't mean they are enforced unequally, but they can be. And that kind of arbitrary attitude toward women, this notion that it's okay to be frivolous about how we enforce laws when we apply them to women, is the problem. And it is why women lose disproportionately in family court. They lose custody. They lose terribly. They lose really important rights in family court systematically in every state in this country. Why? Because they're not entitled to equal treatment by family courts. They're not entitled to equal treatment. So it's no surprise that the data we have today, and it has been shown over and over again, proves women are not treated equally in family court disputes. Men prevail when they should not. Women lose when they should win. And that wouldn't be happening if the ERA were in place, if women had full equality. Another example is something like self-defense in response to a crime like rape. I tell people all the time, if you're raped and you happen to have a weapon with you, you're allowed to kill your rapist. That's technically what the law says. And yet, there was a case in the news just the other day. It was from the UK, but they have the same problem with us in terms of second-class enforcement of rights. It's the same problem in the UK. A rape victim who happened to have a knife on her because she had been raped before happened to get raped again when she had her protective knife with her, which was legal. And while she was being violently raped, she stabbed the man to death. Well, she's in prison for the next 17 years. If she had basic legal equality, self-defense laws would have to work better for her. But because she's a second-class citizen under the same problem legally in the UK that we have here, courts are allowed to enforce self-defense laws differently, resulting in someone going to prison where they shouldn't go at all, but certainly not for 17 years. So I just want to clear that up because it's an important concept. What are we fighting for? Most of the laws don't say men can do this and women can't do that. But that's not the problem. The problem is enforcement and interpretation by the courts. We get second-class enforcement, we get second-class interpretation by the courts. That's the point, that's the problem. And we all need to find language in ourselves to be able to communicate that. And I think the simplest way is that when someone says, what rights do men have that women do not have, we need to say back, that's the wrong question. Let me help you understand the issue. It's really important because we're not generating cohesive public understanding of the nature of the problem. It sounds like we're fighting for something symbolic. Au contraire. So what's the case about? I sued because there is a law, there aren't many, but there is a federal law that explicitly discriminates against women in its wording. So this really isn't even about enforcement. It's really a very black and white problem in the federal code. It's a law that says men must register for the draft and women cannot. So men 18 to 24 are required, as soon as they turn 18, they're required to register for selective service. And women not only need not, but they cannot. So if you logged on at age 18, you're a female, you log on and you try to sign up for the draft, you're going to get an error message. It's going to kick back and say, you're a female, you can't sign up. Sorry. Per se, you are rejected because you're a female. Now, why did I file this case? Because do I think the draft is great? Am I trying to engage women in supporting the warmongering? Hell no. That is not the point of this lawsuit. This lawsuit was filed because there was another lawsuit filed under this exact statute in California federal court by a man named Vikram Valame. Mr. Valame, when he turned 18, said, I'm not signing up for the draft because this discriminates against me as a man because it doesn't require women to register. Okay, well, you'd think maybe he doesn't quite have standing to complain because he's not a woman, he's not being excluded, but he framed it differently. I'm being forced by the government to register, women should be forced. And he's not wrong that he has standing to complain, but this is really a women's rights issue and a women's rights case, and I'll tell you why. It's really important. When he filed his lawsuit, he made two arguments. One, this violates my rights as a man under the ERA, and the ERA is valid, and I want the ERA to be enforced, and because the ERA is valid, women should be required to register. Now, no matter what you think about the draft, you might even say, oh, good for him. We like this, right? This guy's saying on behalf of men, the ERA is valid. So maybe he's our pal, maybe he's our buddy. No. Although he does make a good Article 5 argument about why the ERA is valid, which is to say, he says it's valid because 38 states ratify and that's all we need and the hell with the deadline. He makes that argument and he does okay. But there's much more to our argument about why the ERA is valid. And it is, of course, a long and important story about how we became unequal in the beginning when the 14th Amendment was adopted and excluded us as non-persons. Equal protection rights were given to women in 1868 because that 14th Amendment clause says equal protection rights are for persons. Well, then the Supreme Court consistently refused to recognize us as persons until 1971. And then even in 1971, when they said we were persons, they said, but you're not going to have equal protection rights. You're going to have unequal equal protection rights. You can't even get your head around what that means. How do you have unequal equal protection rights? Well, what that means is we're going to have layers of judicial enforcement of equal protection rights. Some people will have their equal protection rights enforced at the highest levels of very strict judicial review called strict scrutiny. What strict scrutiny does is it forbids all forms of discrimination except in rare circumstances. So it's super tight protection against discrimination. But the court in 1971 gave us not just second-class rights under intermediate scrutiny, which is a bump down, they gave us third-class rights under what's called rational basis. And rational basis lets everything through. If you go to court in 1971, the court will say, okay, you are a person under the Equal Protection Clause, but we're reviewing your claim under such a low standard, it's all going to be okay. Every kind of discrimination women suffered was basically okay after 1971. The Supreme Court bumped us up to a thing called intermediate scrutiny a few years later, and that's where we've been stuck ever since. So intermediate is better than the bottom tier, but it's not as good as strict scrutiny, and that is what inequality looks like for women. It's all about enforcement and judicial review, and how strictly are the courts looking at women's suffering as unequal persons. Why is this important? Because this up here is strict scrutiny. This is intermediate, and all that space in the middle is where women suffer abuse, rape, violence, sex trafficking, you name it. That's right there in that space with impunity. With impunity. Family court injustice, right here in that space. There's nothing you can do about it because it's legal to treat women down here and let all the bad stuff continue because we're not up here. So why does this matter? Because Mr. Valame, in his brilliant idea to sue about women not being allowed to be drafted, doesn't seem to think strict scrutiny is important. So in his briefs and the things he's filed in his cases, he's asking for intermediate scrutiny. And I got a problem with that. In addition, we have learned from the American Constitution Society that his case is going to the Supreme Court. So what do we do in response to hearing that a case about the ERA and about strict scrutiny is on its way to the Supreme Court? The person in charge of how the Supreme Court feels about the ERA's validity is a guy. The person in charge of arguing what level of scrutiny women deserve is a guy, and he's asking for intermediate scrutiny. Oh, no, he will not do that. Not on my watch. No. That is malpractice against me as a woman. That is malpractice against every woman here. That is unacceptable. And I filed the lawsuit, exactly the same kind of lawsuit he filed, to basically say to my judge in my court, you cannot let his case go to the Supreme Court. Women should have the front seat at the Supreme Court on this issue. I'm not saying he can't speak, but when that guy asks the Supreme Court to reaffirm intermediate scrutiny, I need to be in the room saying, I fucking object. I object. And if we don't file our own lawsuit, we don't have a voice. It's that simple. That's why this lawsuit was filed. I want you to understand it because I think people are upset that we would file trying to enforce this hawkish idea that women should be killing people in other countries and we all ought to be dying on the front lines. And, you know, however you feel about the military, I'm not worried about that. It's okay to be against the military and in favor of equality. We just have to use this vehicle because he's forcing us to use this vehicle. And I have a feeling the Supreme Court and others gambled that women would never file because collectively we're anti-war. So we would never do the politically incorrect thing and file a lawsuit asking for women to be forced to register for the draft. So let me give you a little bit more backstory about where the draft issue is so you understand how it even became a controversy. In the 1980s, there was a Supreme Court decision called Rosker versus Georgia, which addressed the question, can women be excluded from the draft? Is that constitutional under the Fifth Amendment? And just as an aside, the Fifth Amendment is exactly the same as the 14th Amendment. The 14th applies to the states, the Fifth applies to the federal government, but they have the same principle called equal protection. So I'm going to talk about the Fifth, but it's really the same as the 14th. So in the Rosker case, the question of whether it was constitutional under equal protection to exclude women from a law that requires men to register for the draft, the Supreme Court said, yes, it's constitutional for one reason. Women are not allowed to fight on the front lines of combat. And because of that, we can't allow them to register for the draft because military readiness is the key point of having a draft, and women aren't militarily ready if they can't fight on the front lines. So we don't want to confuse the people we have in our draft with bodies of women who can't fight on the front lines. Of course, women can do things in the military and always have, but this notion that they couldn't fight in combat was used to justify upholding the constitutionality of the exclusion of women from that law. And Rosker is still the law in this country. Well, guess what? 10 years ago, as of 10 years ago, I should say, all military branches now allow women to fight in the front lines. They're no longer excluded. They're allowed to fight in combat and die, bleed to death alongside men, the same color blood. So what's the justification now? Well, obviously, Rosker is going to get overturned because the only reason the court said it was okay was that women couldn't fight in the front lines. Now everybody agrees that's no longer true. As soon as the Supreme Court gets another opportunity to address the question, they're going to say, we hereby overrule Rosker because the rationale is no longer there. And we now require women to register for the draft, which some women will be happy about, whether they or care about equality or not. Some women probably don't mind being drafted. And my own view is equality is equality. Like you can't have it both ways. If you want equal treatment under the law, then it has to be for things like abortion and things like being drafted. This is a citizenship equality question. You might not like the draft, but you like equality, so you got to do it. And maybe the solution is, if you don't like the draft, to fight against the draft for everybody, but not just fight against the draft for women. So 4 different cases have been filed since that 10-year window. As soon as it was clear that women could fight on the front lines, men started filing lawsuits. Then they were always men's rights lawsuits. We want women to register now. We want women to die on the front lines now. And every one of those cases, although they were successful at the lower court in a couple of instances, they never made it to the Supreme Court. There were attempts to get it to the Supreme Court. They never made it there. Now this case, the Valame case, is going to the Supreme Court. The Supreme Court's ready to answer the question. So his case has been dismissed at the lower court level. It's now pending before the Ninth Circuit. There will probably be oral arguments on his Ninth Circuit appeal late summer, early fall, maybe even sooner. But in the next year or so, there will be arguments in front of the Ninth Circuit. Once the Ninth Circuit makes its decision, the case will go to the Supreme Court. And for me, the most important thing I could do is make sure that my court knows, because my court where I filed my case, my court is already aware. The way I wrote my lawsuit, I put right out there, this is filed because of the Valame case. So my judge is going to know that my goal here is to hitch our case to his. We can't stop his from going, but we can connect ours to his and let the Supreme Court know when we ask them to review our case. You need to take these 2 cases together because the Valame case is going to answer 3 questions. And I'll wrap it up with this. Number 1, is the ERA valid? That is going to be answered by the United States Supreme Court in Valame's case and hopefully in our case as well. regardless of the ERA's validity, are women now subject to the draft because they are now fighting on the front lines? The answer to that is going to be yes. The third question is the most important one. It's the one I raise and Valamé doesn't raise. If you're going to require women to register for the draft and elevate us to full equality for the purposes of bleeding to death on the front lines of war, you're damn right you're going to give us strict scrutiny. I want strict scrutiny. I'm not even going to argue intermediate scrutiny. I'm arguing strict scrutiny. I'm going to make very clear to every court where I argue these issues moving forward, the time has come. You're asking women to die for their country. You will not ask them to die as second-class citizens. The time has come. Strict scrutiny, period. That's our case, and we need your help.
Okay. All right, great. Thank you for that wonderful summation there. That was really helpful, and we'll take questions after we hear now from Jean Sweeney. We need to, and you know what? I didn't even introduce. Oh my God! You know, everybody pretty much knows Wendy. A lot of people on this call, I think. But you know what? I didn't even read your bio.
That's all right.
You know, let me go to this for a minute. Give me 1 second here. Gotta find my other, where, here we go. So you know what? I just want to read this though quickly, because just in case anybody isn't familiar with Wendy, you know, she's an adjunct professor of sexual violence and law reform at New England Law, Boston, where she also co-directs a women's and children's advocacy project under the Center for Law and Social Responsibility. And, you know, they've run the Judicial Language Project and the Hate Crimes Against Women Project. This is really important, I think, for people to know that, you know, we're working on trying to get, Wendy's working on trying to get hate crimes recognized, you know, when they're perpetrated against women. She was a visiting scholar at Harvard Law School and served as the Mary Jo Frug Assistant Professor of Law at New England Law, Boston. And she's a former child abuse, sex crimes prosecutor, founded the first organization in the nation to provide pro bono legal services to victims of violence involved in the criminal justice system. And Wendy's an impact litigator. That means, you know, she's going after cases like this, you know, because it's a strategic way to get the ERA recognized. And, you know, she's authored some really interesting books. You can look here on the website at the write-up on here for more information on this. But you know what? Let me just see if I can put this in the chat. The unequal protection of the laws for women as constitutional terrorism. So how come nobody knows about it? And is one, and then on justice for some. That's a law review article, excuse me. And then she's written a couple of books on justice for some, and then Oh No, He Didn't, Brilliant Women and the Men Who Took Credit for Their Work. So maybe, Anne, can I ask you to take those off the website, those links, and put them in the chat for people, just so they have that. So and then now we're going to hear from Jean Sweeney, who graduated from the College of the Holy Cross as part of the third class of women, and is a New York attorney who spent 15 years on Wall Street as counsel to the money managers. In 2001, she joined the litigation practice of Maloof and Brown, LLC, as a managing attorney. For the last 12 years, she has had the privilege of following her passion of getting women to be honored and respected as equal citizens. She was one of the activists working to get the last 3 states to ratify the Equal Rights Amendment, and has worked for the last 5 years on getting our Constitution published with the ERA by leading the National ERA Publication Task Force. She's also an award-winning photographer, Kripalu-trained yoga teacher, writer, speaker, and founder of Rethinking Eve, LLC, a business focused on uplifting women. So go ahead then, if you would, Jean, and tell us what your efforts have been pre and post the ERA fight to get Biden to publish, to get the archivist to publish.
Well, hi, everyone. I mean, there's so many people here that really know the background and all of that. I mean, I think that I met both Wendy and Kamala early on in my my journey with the Equal Rights Amendment, and have tried always to support them and either parallel their work or be right there with them. I was part of the ERA coalition when Trump derailed publication of the Equal Rights Amendment. And that was January 27th of 2020. And then when Biden was coming into office, I was quite vocal with the ERA coalition about Biden publishing on the first day. And he did not publish on the first day, but he created the Gender Policy Council. And then we were told that we had to wait until Garland was put into office. And then we had to wait until Schrader, the Assistant Attorney General, was put into office. And there was a point where I think myself and a number of other people were like, something smells here in Denmark. So I actually peeled off and created the National Publication Task Force. And I have had a Zoom call every Thursday at 2:30 going on now for like 4.5 years. And it's any of you gals are welcome to come in. It's an open call, and people come in and they add their time, talent, and treasure to the movement. And it's absolutely amazing that what's happened is that unbelievable people just show up, and they show up with unbelievable gifts. So someone showed up, I think was it Patty? Somebody showed up and said, oh, well, I put the ERA on Kindle. So we have the ERA on Kindle. And Kathy Teleban was able to give me the ERA, the Constitution, and we're working on actually creating little pocket constitutions that have the 28th Amendment printed at the end of them. So I try to work in concert with Wendy. I try not to, go up, that we're working kind of together. And with Kamala, we're kind of working together as we do this dance. As we go forward right now, I think there's a lot of flux. I think this case that Wendy has is fabulous and fascinating, and it's just it's amazing. And I think on the other side with publication, we just have to brainstorm how we can help on the ground to actually get the ERA published, for people to understand the 28th Amendment has been added, and get people to apply that when possible. So that's kind of a short story, and I'll leave it there for your questions or comments or whatever. Thank you.
Okay, thank you, Jean. Yeah, it's kind of like the ERA Publication Task Force kind of took the position, well, we're if they're not going to publish it, then we can, and we can get it out to people, and start encouraging everyone that's filing lawsuits to argue for strict scrutiny, and claim the ERA is valid, because it's met the requirements. It's the only amendment that's ever met both requirements, and not been published under the Constitution. So let's go to questions now. If you want to raise your hand or unmute, hopefully I'm going to close this out so I can see more people. Who would like to go first? Anybody would like to?
Fran
Okay.
has her hand up.
Okay, Fran, go ahead.
Hi. Hi. I hope I can be heard. Yes. Can I be heard? Okay, great.
Yes.
Okay, first of all, thank you so much for these presentations. Wendy, you were clearer than even you usually are today. People may not know it, but I produce one of the only feminist radio shows on terrestrial radio. That's radio with a tower. And Wendy's been on the show, Joy of Resistance, which I'll put in the chat, maybe 6 or 7 times, right? I have backed you to the hilt, Wendy, because nobody gives a clearer definition of why we don't have equal rights in terms of the ERA than you do. Okay, very useful. So I have a very serious question, despite the fact that I support the suit on many levels, including the fact that I do not want to see the men's rights movement strengthened, which I believe it would be by Bellamy winning this suit, right? His coalition to defend men's rights or something, you know, they believe men should have a say in whether women get abortions. They believe the gender wage gap isn't real, just horrible anti-feminist stuff. So I certainly don't want to see them win anything. However, I have a very serious question. It's a little involved because this is an involved suit, so I hope people will bear with me. It has 2 premises. One, that when you do a court case of any significance, you want to have a public outcry supporting you. I mean, this is a truism, and I say this as an organizer of many demonstrations in front of courthouses. And as Kamala said, you know, we want women to come to the case for Adam Eidinger, et cetera. Very important. So my question is, given at the very least ambivalence that so many women will have about the right, if you want to call it that, whether it's a right or an obligation, however women see it. A lot of women are not going to be too happy about having to register, to put it bluntly. So my question is, in a suit like, well, the other part of it is that you want every chance to win because this is a test case, right, for the ERA. It's a critical thing. And if you lose it, you are set back for the ERA, I would assume. So my question is, can we afford to have as the test case for the ERA a case that is not likely, women are not likely to come to the rafters, come out in droves and masses, in my opinion, for the right to register? Can we afford to take a chance with the ERA on a case that will probably not, at least in my opinion, get that kind of backing from masses of women? Well, that is my question.
It's a good question, Fran, but the answer is it's irrelevant. You're asking a question, the answer to which is, it doesn't matter what we want, it's going. Valamay's case is going. So we can either sit back and, file our fingernails and hope he wins for us, hope a men's rights group wins for us, or we play the same game. We've got to persuade the Supreme Court to listen to women in this case, in his case. The only way to do that is file our own case under the same law. Otherwise, we have no basis for asking the court to consider our voice in his case. It's not like I can file a lawsuit under an equal pay case and then say, oh, why don't you glom us on to the guy's mandatory draft case. It's not how it works. We have no choice. We have to file this. We have to make the point that because he has captured the ERA as the forefront of his claim that this is an unconstitutional law, we either sit back and twiddle our thumbs and let him be in charge of what the Supreme Court says, or we force feed ourselves into his case. And the only way to do that is to file our own case. There is no other way to do it, period.
And what I would say regarding getting masses of people to put skin in the game on this case is we need to raise money so that we can play the PR game. And I'm sitting here in Hollywood, California, and I can tell you right now that the way that information gets out in our society is completely pay to play.
Yeah.
If we want articles in newspapers, in Vogue, on TV, if we want people, because as Wendy explained, it's pretty clear. You want women to die for their country, and yet you don't want them to have equal rights. You want the amendment that has fulfilled all the requirements to simply be ignored. No, it's not a difficult argument to make. It's just a matter of the amplification or lack thereof that is stymieing us right now. So we know that millions upon millions of women voted for Kamala Harris. We know that at the beginning, right after Trump was elected, there were all these phone calls where hundreds of thousands of women got on Zoom. We need the funding to be able to reach out to those exact women and explain what's at stake. And we have a little bit of time. And I think that since Valame is probably not going to land in the Supreme Court for a year, and Adams' case is landing in court in the DC federal court in October, we can start to build, use these two things to build towards that, so that by the time our case and Valame hits the Supreme Court, everybody in the United States has heard that what we're actually talking about is equality for women, at which point women will be so horrified by everything that's going to transpire between now and then, that with some funding, we should be able to get on The View, get Oprah to talk about it, get these people that were always talking about why won't so-and-so do, why won't Rachel Maddow talk about this? Why won't so, well, I'll just be very clear, because we don't have the money. Money talks in this society.
Yep.
Money is the voice. That's why corporate people have a louder voice than us who are non-people. So, you know, we need Melissa Gates. We need whoever the hell it is to put some money behind this so we can amplify what we're doing. It's not a difficult sell.
But can I just say one quick thing in response? The money is not going to come from those women who met about Kamala Harris. The money is never going to be flowing from any partisan thinking human. This is a fiercely nonpartisan endeavor. So where I would go looking for money, and it is largely an issue of money. I mean, it's too bad that we can't get anybody to care about a story without paying, but that's the nature of the beast. And you know, the other options are to fly a blimp over and, you know, drop balloons out or something like that. Well, we can't do that either. We really have to make this the news. And the way to make this the news is not just to keep pounding the table and saying this is a moral argument, we have the moral upper hand. That's never going to cut through. So we have to use social media, which can sometimes make things go viral, TikTok and all these things that I know nothing about, don't know how to use. But we need to get it into the minds and brains and feelings of young people so they can do their social media stuff with TikTok, that sometimes you don't need money to go viral on TikTok.
That's just wrong, Wendy. I know for a fact that there are large companies that get paid a lot of money to make these things go.
Oh, I don't dispute that. I don't dispute that. I'm saying there are two different ways of making people pay attention.
But we can do social media, but that also needs money.
It does. And what I'm trying to say to people is there can be grassroots efforts, just like a story of, you know, if there suddenly became a sinkhole in the middle of Manhattan, nobody paid for the news to cover that, but the news will cover that. So there are two ways to get news. One is to make people pay attention because there's some, you know, event. And then the other is to pay for it. And even if we pay for it, I just want to be clear, the money against us is enormous. It is enormous. In today's value, eradicating Black slavery came to about 12 billion a year in today's dollars. Like that's what it cost wealthy corporations and moneyed interests back then. It cost them 12 billion a year in today's dollars to liberate Black people from slavery. That same question about giving women equality, crunch those numbers in today's, it's like 4 trillion. I mean, this is so much more expensive that when we say we need money to elevate, that's true. We also need to realize that we're never going to have that amount of money. So we have to be really careful about how we use it, who portrays what issue, how we make the points, who we align with. So what I'm getting at here is I think we need not waste one dime trying to get Democrats or Republicans on our side. They both hate us. They've both done just very destructive things to this initiative. The people that are going to help us are going to be people like, and I don't know their names, groups that are opposed to Citizens United, for example. Those are pro-democracy, fiercely anti-partisan, disgusted by the whole concept of a dichotomous, left-right system. They feel that alone is anti-democratic, and it is. We need to reach out to brand new people, and this is part of what costs money. Brand new people who maybe don't understand why women's equality is the same kind of issue as Citizens United.
Yeah, I want to jump in here because one of the organizations I talk about a lot is Move to Amend. And Move to Amend, it has a corollary to the ERA. It's an amendment that's been in Congress since 2014. It keeps getting reintroduced, but it's to end the two legal doctrines that actually allow corporations to run every aspect of our lives and interfere with, our rights. The rights of actual natural persons, and those are the two legal doctrines are corporate personhood and money as protected speech. And we need to really get behind that and connect with Move to Amend.
What we need to do is persuade them
to help
that if they support women's equality, we will have a louder voice on their issue. In other words, we're not wasting our resources on them. They need to waste their resources on us. Strategically, we need to persuade them that if they help us by marching at the courthouse and doing all the things we need, right? If they support us, we will then be a louder voice for them, but we come first.
Here's the way I would frame it. We've got a man here who's trying to use use the ERA to make women register for the draft. If we frame it that way, I think you'll get a lot of women's attention and a lot of people.
I don't, because then it becomes anti-draft and they won't align with us. We can't do that. This is not. No, this is a moral argument. This is a moral argument, and I got to be clear about. Let's talk some more questions before. Go ahead.
Can I just say something? Wait a second. There's other people that have their hand raised.
Yes,
so
go ahead.
Yeah, I can't see them.
I can. So Romy had her.
One. I see.
Romy had her hand raised. Romy, are you still interested in speaking?
Well, Kamala kind of answered my question, which was how do you deal with the backlash? Because I was on the same page as Fran and foreseeing that this was going to cause a lot of women, of course, to be antagonized. And I think it's absolutely essential to do what Kamala was saying, because if you slip up and you don't do it, then you have women being forced into the draft, and that has so many ramifications. It's so sickening to think about women being, again, being used for cannon fodder for the empire, so to speak. And there was something that Wendy said, though, and now I can't remember. I did want to say, though, that I do not want to be on the opposite side of the table ever from Wendy. If I did, I would never want to
That's
go.
a dangerous place to be.
It just, she just cut through everything like a knife through butter. And, I came here thinking, because I fought against the draft in the 60s, just horrified at the idea. And I think there's a sizable segment of Americans, both men and women, that are going to be really, really put off at the idea. But I think the argument that was just mentioned of saying, here's a man using equal rights to put women down the way men have done so often, twisting things around that were once something positive for women and using it to once again put us back down. I think it's going to make people so angry, and I mean women so angry, that I think you might just get your help on Twitter and all the other places.
Yeah, that was my idea, and I think, if we then say, and, we have to fight this fight because, it's not our choice. This case was not our choice. It was foisted upon us.
Yep.
I see, Shannon and then
Yeah.
Colby, and I'd like to put my name on the list after that.
Okay, Shannon and Ann and who else?
Well, Colby, I guess Colby can go first. Shannon first,
Oh,
then
and
Colby, and
Pam.
then me,
Okay, Shannon, go ahead.
and then Colby, and then me.
Okay, and then Pam. All right.
Is Pam on there too?
Yes.
Good morning, sisters. Good morning. Always grateful to be with you. Happy Mother's Day to the mothers here. Happy Mother's Day to your mothers who gave us you, the
Yeah.
fighters making the changes. So I'm grateful every day. I'm a Canadian, moved to now a US citizen. So forgive me, a lot of these things are new to me. Women didn't get rights in Canada till the charter in 82, and now they've undone that. I fight on a daily basis about the gender identity. I think it's the same thing where men are getting into women and using women's things, such as even the ERA, to destroy women's rights down to the core. So I'm on a different place. But one thing I'm wondering is, and I'd like to tie that into the ERA, but one thing I've only come to understand lately is the levels of scrutiny used in the courts here. And I understand I'm ignorant on a lot of things, but I wonder if I got about 3 points, but one, that's a good way to help people understand the difference when it comes to the courts, because I, as a woman, didn't understand that part. And two, what is the importance of what they call interveners and amicus briefs? I've learned a lot about this in the law stuff with the gender identity BS, about how that's affecting things, and is it possible to be a literal amicus brief and intervener in that other case that you're trying to tie to? Thanks for your work.
Yeah, so the answer is yes, I could probably file as an intervener in the California case and potentially also write an amicus brief in the California case. I've actually done that in California cases in my career, but it is such a weak position. The court is, especially with an amicus, the court can just ignore you. I mean, an amicus brief is like spitting on a fire, it's just nothing. And then in terms of intervening, it's really up to the court. The court has some substantial discretion to not let you intervene. And I would imagine the judge would never let us intervene. And so we'd waste an incredible amount of money and time. I shouldn't say money since I'm free, but the court would we would waste a lot of resources trying to intervene, and we would fail. That's my feeling. So having my own case for us is the only way to be guaranteed the voice we're talking about in a significant enough way where I want to make it really hard for the court to say, we think a man should be the voice at the Supreme Court on this issue, even though this women's rights case is right here, led by women. See, if I didn't file this, the court would still take his case and do exactly what they're planning. And make no mistake, the Supreme Court plans cases like this. This is not like accidentally getting to the Supreme Court. These things are quite planned. So the Supreme Court, I think, in terms of who's behind all this, They're just delighted that a guy's case is going to determine women's issues, and that they were gambling no woman would ever file such a case, because women tend to be essentialized around this question of war and the draft and so forth. So my view is, once we have this case in place, it is now politically really hard for the Supreme Court to say, well, this is the case we had, so this is the one we had to decide. And this man only asked for intermediate scrutiny, so that's what we gave him. Under the word sex, for constitutional purposes, he asked for intermediate scrutiny. We gave him what he wanted. Isn't he delighted? And everybody cheers for the guy. And we're over here going, no, we want strict scrutiny, but we're not even in the room. So the point is, and I want to keep saying this over and over, we can't even shine a light on how extremely inappropriate and offensive it is for the Supreme Court to decide a women's rights issue or the ERA's validity without women being not just in the room, but in the lead. If we didn't file a case, we would have no basis for saying to the Supreme Court, when they do issue their decision, what were you thinking? What were you thinking, deciding a women's rights case without a woman in the lead? So then the Supreme Court would say back to us, well, you should have filed. You weren't here. You could have, and you didn't. We cannot accept the Supreme Court of the United States making such profoundly important rulings without us being in the lead. And we can't even guarantee ourselves a seat, right? Here's what to remember. We're going to go through our case in Massachusetts, and I'm going to be pushing every step of the way to get this case to the Supreme Court. But if we file with the Supreme Court and Valame's case is already up there, and the way it works is I would file a request saying, please put my case together with his. These are similar. You should decide both of them. And here are all the reasons why you need to have both of these cases together. They can say no. They can say, let's decide the case with the guy in the lead and we'll pretend the women aren't even here. They can still do that. But at least with our case, we can create some discomfort for them.
Right. We can force the issue man versus woman, and you're going to say no to a woman's case, and that's going to show, and it's all going to, sometimes saying no and forcing no is the way to do it.
All we
now,
can
the
do.
other thing, have you been in touch with Wolf, like Women's Liberation Front, and some of the women
They've invited
fighting?
me to speak in June, so I'm going.
Okay.
Oh,
Yeah.
wonderful.
Okay, that's wonderful.
I have a question then.
Hobby,
Okay,
wait,
Wendy, hang
Hobby
on,
is next.
Romy, yeah.
Hobby is next.
Yeah, who is next?
Hobby.
Cobby, thank you. Go ahead, Cobby.
My question's a little bit different. Thank you, Wendy, and I agree with you that we have no choice, but we have to act if we want women at the table. And I have, even before the 10 years ago, always said that the majority of moms care and they're vested in their children like few other things. And in that case, don't want to see any of their children killed, whether they're male or female. And I say that because now I've been reading that we have a defense secretary who is doing what he can to remove women from the military and particularly from the front line. And if he is successful at that, will these kinds of cases, don't the courts sometimes saying, oh, we don't have to decide, it's not like that anymore?
No, I mean, it's a really good question. So what you're talking about is whether an executive branch official can legally change the policies that put women in the front line, and therefore undermine the argument here that Rosker needs to be overruled. The answer is, in theory, it makes the case weaker, but it doesn't change the fact that Valame's case is postured the way it is, and that there is this case called Rosker where the court had to struggle with the question, is it constitutional to exclude women? So because it was a policy and not a law that eliminated the problem of women not being allowed to fight on the front lines, it is possible that if all of the policies get reversed, that the case becomes weaker. What that could mean for Valame's case, and certainly for ours as well, is that changes the Supreme Court's desire for the case. So maybe they say, you know, and they sometimes say certiorari was improvidently granted. So even if they take it, they can dump it, right? They just sometimes change their minds.
Yeah.
But the other thing that would be really devastating, so that could make a difference, but it might not. And then again, you know, 4 years from now, are we going to be back in the same situation because there's a Democrat? Maybe, you know, but this is going to happen. This issue is eventually going to get to the Supreme Court, maybe not now. And for that reason, for the reason you mentioned, but also this reason, because we have now created our own case, and it is a very provocative case, because we're not just saying we want to be at the front of the table when this issue is decided because it's our thing. And they were hoping we wouldn't file at all, right? But the reality is, Congress could pass a law mandating that women register. And that would moot my case totally. And it would moot Valame's case. So it's a slightly different way to get to the same result, which is the Supreme Court never has to decide any of this stuff. And women do end up registering for the draft because a statute overrides a policy. So that could happen. And there has been a law proposed with Congress to mandate, you know, to amend the law to mandate that women also register. But
and the Defense Department has the list of women for years now.
Oh, yeah. Oh, yeah.
Keep track.
That was when the Democrats were in the majority, though, wasn't it?
Yeah, I was
Okay,
on.
so Congress could mandate that women register.
They have to amend the law, right? So a law overrides a policy.
Right.
Okay.
And it would be interesting to see whether Congress felt pushed to change the law in response to these things we're hearing from Washington about, you know, let's get trans people out of the military, let's get women out of the front lines, right? What's going on right now in terms of what we're hearing about those policy changes could be intentional, strategic, and meant to provoke Congress to enact the law that then moots both of our cases, because now that we've filed, the people who were behind Valame and hoping no woman ever filed are pissed off. They can't now have their smooth sailing case go to the Supreme Court, reaffirm intermediate scrutiny, force women to the front lines. We've caused a problem for them. And this could be what we're watching. This stuff about getting women out of the front lines could be strategically designed to hurt us. Not hurt our case per se, but provoke Congress to change the law, which then absolutely destroys our case.
Oh, fascinating and horrifying. Okay, thanks.
Okay, so,
Ready to speak? If I could speak.
And go ahead.
Yeah, I feel a little torn about this issue because on the one hand, certainly I agree with the feminist songwriter Kristen Lems that said, yeah, I'll be drafted and I'll fight beside my brothers against your goddamn wars, which is what Kristen Lems said. And I agree. I agree with that. Equality is equality. I have a problem with, I guess, the original concern that Fran had about trying to build support. And how do you argue that getting drafted is actually a right when it seems like
it doesn't have to be a right.
It's a violation of rights that neither men nor women should have to undergo.
It doesn't have to be a right in order for us to win, because the Equal Protection Clause is interested in equality under the laws, not just equality under the rights. It's all laws.
The concern is trying to get enthusiasm for what will look like, and I understand it completely. Oh, sorry. Can you hear me?
Yeah.
They understand the dilemma that you're facing. The legal dilemma is you know, obviously a big one. And the importance of you know, having the highest level of review is really extremely important. But how are you going to get? It's going to look like we're saying that being drafted is a right and we're being deprived.
No, I'm not making the argument that it's right. It's clearly an obligation. But in a constitution that creates both rights and responsibilities, that's just the way it is, that you can't claim equality just for rights and allow inequality for laws that aren't rights, but that are, obligations. It's a social compact. You got to do it in both directions. And it's kind of an immoral argument, if you ask me, that somehow you can have equality for rights, but inequality for things that aren't rights. It's kind of, it's not immoral. It's irrational. It's irrational.
Okay,
I don't see the basis for that distinction. It doesn't have to be a right. The Equal Protection Clause doesn't speak to rights, and no one would argue that the only thing Americans have are rights.
okay.
Laney has her hand up, I believe.
Pam was next.
Okay.
Go ahead and unmute, Pam.
Can you folks hear me?
Yes.
Thank you. Well, first of all, I'm very delighted to be here. I want to express what comfort it gave me to know that Kamala and Wendy were on patrol on the ERA stuff, as I finally realized when we came down to the last line of the Biden administration closing, that we were probably not going to have it ratified, and that we were going to have to figure out what to do next. So thank you very much for your leadership. Whatever else happens, you are doing the right thing. As far as questions, I have never heard of the Valorme case. Of course, it's probably because it's in the district court and not moving forward to an appellate place where I would see it.
It's in the Ninth Circuit now.
Okay. So I assume your case was filed in the Ninth Circuit, Wendy?
No, mine's filed in Massachusetts.
Okay. So you're going to say that there's a conflicting case and that there are enough similarities in the case to bring it into a consolidation in the Supreme Court?
In my complaint that I filed, I mentioned Valorme as the reason we filed.
Okay. So who is behind this Valorme case? What are the groups that are funding it?
Funny you should ask. We've done a little background intel. Maybe Cam can fill in a little bit too, but Natalie White has been doing some background work, as has Jean and Nicole Bates. Nicole was the one who first learned about Valorme and shared it with me, and we, both had the same feeling about what he was doing. It was so obvious, just really obvious. But she found out that he is in college and is a member of an organization that is funded by the Koch brothers.
Yep.
What's the organization, just so I can look it up?
Coalition.
Do you know, or do you not want to share
No,
that?
no,
here?
I forget.
Okay.
I think it's called Coalition for Men's Rights.
But it's the Cato Institute.
Cato Institute.
Yes, of course, they're in back of that, of course.
Okay, Cato Institute. Thank you. That is Koch.
Yeah.
And who is funding you? You say you're working for free. Good Lord.
That's
No one is funding us.
No one funds me. I've been doing pro bono work for 40 years because because the money behind women's rights is on the other side. It's always been on the other side. It's pornography, it's sex trafficking.
Right.
Maintaining women's subjugation is an enormous, it's a profitable thing to do. And any money on our side is, generally speaking, either very small or corrupted. So for example, most of the mainstream women's groups that get large amounts of money, they're just controlled opposition, if you know what I mean. They're getting funded to manage us into oblivion by having women go off and do busy work. That's hard to get your head around when you're just young and you're trying to figure out what to do, and you go sign up for this organization or that organization, and you realize you've wasted 20 years of your life and they're doing nothing but busy work. So once you realize that there are no funded groups doing the work that needs to be done, your only choices are don't do it or do it for free. And that's how I found my place in the world.
Well, that's fantastic because it's obvious you're very sophisticated. I've read your Ferrero, the previous case. I've read the materials I could find there. I've listened to you and Kamala on your equal ERA discussion, and your discussion of strategy in this case. I can see how incredibly difficult this is, the posture you're in going in, the disadvantage of the main subject matter, the fact that Hegseth may put women out of combat lines and cause a problem there, the fact that a man is bringing this case and we're going to be dragged around quite a bit. This is a very, very difficult situation to walk into, but I want you to know, I totally understand why you're doing it, and I totally approve. I've been thinking quite a lot about how it is that so many of these discrimination cases end up benefiting men. And I've been comparing some things, looking at Craig v. Boren, for example, in which some young guys sued because they didn't want their ages to interfere with their drinking. And that helped establish theoretically that we were covered by the 14th Amendment, which I don't think we are at this point. At least it's very shaky if we are.
Well, that's the case that gave us intermediate scrutiny. We got covered by the 14th
Yes.
in the 1971 Reed versus Reed case, but Craig is what bumped us up to intermediate.
Right. And I hope someday to be able to ask you questions about some of that, because I'm sure you know everything about why nobody cites Reed v. Reed, what's happening with the class actions and all that other stuff. But I got to move on as quick as I can, because we have other people that want to ask questions, and I have about 20. And I'm not going to do them
Pam,
all.
Very quickly, the law review article that Carol mentioned at the outset, that is all my knowledge. So,
okay, excellent. Thank you so much. Well, talking about intermediate scrutiny, what are the chances that the court might say, yeah, you're right, to the guy, you don't need strict scrutiny. We're going to put him down at rational basis like we did in Dobbs.
No, I don't see that. They're not going to send us to rational basis. They will reaffirm intermediate scrutiny. That's because, number one, that's all the guy asked for. And if you only ask for second-class treatment, you're going to get second-class treatment. And let me say it as an aside, every women's rights group in this country, the leading ones, all the abortion rights groups, Planned Parenthood, all of them, and all the major women's groups, including the National Women's Law Center, Feminist Majority Now, all of them, whenever they go to court, whenever they write a brief, whenever they work with lawyers, they only ask for intermediate scrutiny, or worse. I don't understand that as an academic. It's like representing a Black person while they're enslaved, and everybody around you is saying slavery is inhumane, and you go into court and say, I'd like you to keep slavery legal, Your Honor. Why would you do that? Mm-hmm. Why would you ask for it? Yeah. You might not win liberation, but you ask for it, right?
That's right.
You ask for it. So there is very much a funded / concerted effort to make sure that all like you said, sophisticated lawyers who are doing high stakes litigation are trained to only ever ask for intermediate scrutiny. Mm. I'm not obedient like that. That's not what I do, right? Mm-hmm. And part of reform work as an attorney and an academic, part of the reform work is being able to say to an appellate court in particular, I know that's the law, I reject it. Most lawyers aren't doing that. They're not trained to do that, but it's important to do, especially like Plessy versus Ferguson. And then we got, Brown versus Board. How did we get there? How did we get from Plessy to Brown versus Board? Somebody objected to the precedent. So I even write in my pieces where I've discussed the nature of intermediate scrutiny that Craig versus Boren is women's Plessy, because it's got us down. Right down.
Yeah, that's
we
good.
want
that's
Brown
good.
versus Board. Who's going to ask for it? I don't know. But you have to ask or you can't win. That's the gist of it.
I still am very concerned about the idea that they might announce, since it's been, obviously Clarence Thomas would vote for it, Alito would vote for it, that even though the guy doesn't specifically ask for anything but intermediate scrutiny, the court certainly would love to knock us down to rational basis.
But if they
there will be support on the court for that.
The reason they won't do that, Pam, is because rational basis still gives us personhood, right? So it's not because there's no legal way for them to do that unless they say women are not persons, which takes us before Reed. And they're not going to do that. They're not going to declare women non-persons. And to say, so in other words, to take us to rational basis, we would still be persons. And then they couldn't use, well, the 14th Amendment didn't mean to, they couldn't use textualism.
Analysis. Yeah.
They couldn't, because if textualism wins, then we're not persons. And they won't do that. That they will not do. That, that precedes 1971. I think not only are they going to reaffirm intermediate scrutiny, this is why they're going to do it. And I'm going to give you a little bit more information about stuff you might not know, but you might be familiar with, so bear with me. One of the cases that's going to have enormous effect on our case and on Valame is called Scrimetti. I don't know if you're familiar with it. Right. So Scrimetti was argued in December. Scrimetti is a transgender-led case where transgender people were complaining about a law that denied medical care to trans kids. It went very fast to the Supreme Court. Again, intentionally spoon-fed to the Supreme Court. The lawyer for the trans people made 2 arguments in front of the Supreme Court about whether they get certain level of protection under the 14th Amendment. They said, we want our own category. So as transgender people, we want a categorical space, and we want intermediate scrutiny. And they said, alternatively, we fall under the umbrella of sex because of Bostock, where sex was determined to cover transgender for Title VII purposes. They said under the umbrella of sex now for the 14th Amendment, which is pretty comparable to Title VII, we want you to declare that transgender is part of sex. And because sex gets intermediate scrutiny, we want intermediate scrutiny. Now, interestingly, they were asking for intermediate because the lower court gave them rational basis. So they will be cheering like nobody's business when they win intermediate, which they will. The case is going to come down in June. The decision will come down in June. There will be so much celebration in this country by the LGBTQ community saying, this is terrific, we have equality. And they won't have equality because they'll have intermediate scrutiny. When I watched the oral argument and heard a transgender advocate ask the highest court in the land to give the word sex intermediate scrutiny, when I knew that we and lots of other people were screaming and yelling and saying, what? We've been fighting for the ERA for the sole purpose of getting out from under intermediate scrutiny up to strict scrutiny. How dare you, you transgender advocate, how dare you take sex to the Supreme Court and ask to reaffirm intermediate scrutiny when we're dying and killing, like we've been fighting for 100 years for strict scrutiny. Don't you dare ask to legitimize strict scrutiny for us. You want strict scrutiny for transgender, that's your business. I wouldn't ask, if I represented a transgender person, I wouldn't ask for second-class citizenship. But if you want that.
Isn't the problem here, though, that gender identity and sex are being conflated?
Yes, but no, not in Scrimetti. In Scrimetti, they were not conflated.
They were in Bostock.
Yes, the Bostock argument was just the word sex covers gender ID. In Scrimetti, because it's a 14th Amendment argument, they were saying, give us our own category. And if you don't like that argument, give us a space within the word sex, which is an existing category. Under both arguments, they said, we want intermediate scrutiny. And I almost fell off my chair because I'm like, you're not allowed to ask the Supreme Court to reaffirm what we're fighting about. Yeah. So they will have a big celebration when it comes down in June and they get intermediate scrutiny because that's a bump up from where they were. But here are the implications for our case. Scrimetti is not only going to decide that intermediate scrutiny is okay for sex, but mind you, it's a decision that will say sex as it applies to trans. The Supreme Court then needs a women's case To
Mhm.
be able to say, well, when we said sex
Right.
gets intermediate scrutiny, although
Yeah.
that was a transgender case, we're also going to apply it to women. And here's the
Mhm.
case where we're going to do it. It's called Valame. Valame is the third case in the 3-part series of cases intended to reaffirm intermediate scrutiny and continue to subjugate women, but to do it by blaming trans people and men. And that was Bostock, Scrimetti, and then Valame. That's
Right.
the plan.
Right.
Those 3 cases
Right.
are intended to erase us. And look who's in the driver's seat on all 3 cases. Trans people, and men. Women aren't even in the room at all. So
This is a
how's
problem.
this going to affect, how will this affect our case? This is really important. 2 things to remember. In addition to Scrimetti having a lawyer as an advocate asking for second-class treatment, intermediate scrutiny, they were also asked, the lawyer for the trans community was also asked by Justice Alito, well, what's your position on mutability? Because mutability is a really important factor that the Supreme Court takes into account when deciding whether somebody is worthy of strict scrutiny. Now, go back to the early 70s, there were a series of cases that said sex, like race, is immutable. It is determined at birth and it cannot be changed. And because it equated sex with race and said it was immutable, we were now potentially going to get the top tier strict scrutiny, but only after the ERA. You have to get the ERA, and then because you are immutable plus the ERA gets us strict scrutiny. That's how the court laid the groundwork for where we are now. Well, if this transgender Scrimetti case upholds the concept of intermediate scrutiny for sex and rules that sex is now mutable because
They're arguing,
transgender.
by the way.
Oh, I love it. I
know,
hadn't heard that before. I
that
get it.
causes a
Yes, what
huge
happens?
problem for us
Oh,
because
boy.
when our case gets to the Supreme Court, or when Valame's case gets there, the Supreme Court is going to say, well, 50 years ago, sex was immutable. Now we see that sex is mutable. So it doesn't matter if the ERA is valid because women only get intermediate scrutiny regardless of the ERA because they're no longer immutable.
Yeah.
That gives the Supreme Court the ability to say, as for Mr. Valame's argument about the ERA being valid, it gives the Supreme Court the ability to say, we don't have to decide if the ERA is valid because even if it is, it only gives women intermediate scrutiny. That's the current posture of Valame's case with Scrimetti.
Let me break in here because, yeah, this has been the awareness that we've had for quite some time that that gender identity is basically the whole ideology is focused on erasing women as a sex class, and getting it conflated with sex in law is a huge problem.
It wouldn't have been a problem, Carol, if they just asked for strict scrutiny. It wouldn't matter if everybody got strict scrutiny. It's this manipulation of gender identity to justify the reduction of women to intermediate scrutiny and to change the nature of sex by the misuse of transgender people as an excuse to change the immutability issue for women. This is a construct. It's a false narrative.
Yeah, but we also have the Equality Act rearing its ugly head for the second time, which the problem with that is the conflation of gender identity with sex. And and in fact, I wanted to recognize Pam as being one of the, she's an attorney who helped the Feminists and Struggle group write the amendments, feminist amendments to the Equality Act, her along with Ann and another woman.
That would be Tina.
Yes,
Tina who was here.
Three attorneys worked on that for us because, they teased out the problematic areas in the Equality Act, and we're now going to be facing that again. So this is a huge problem.
Well, yes, except
Well,
that if we win our case, you don't even have to fix the Equality Act. So let's focus on, winning it at the highest level. Let
Yeah.
me also emphasize two things. One thing about two sides of this coin on immutability, because it's really important to understand why we have to be fiercely nonpartisan on this and hate both sides. Here's why. Remember that I just said we need two things for equality and strict scrutiny. We need the ERA to be valid, and we need to be immutable, because that's what the Supreme Court has said. If you ask me, immutability should have nothing to do with whether you get treated equally under the law. It's a stupid thing. It's ridiculous. You should get equal treatment under the law, regardless of whether your characteristic is mutable or not. That's just a dumbass thing to have said, but the Supreme Court said it. So they're thinking about it and they're planning to use it against us. Well, why is this interesting? Because in the past year, this is what we've watched. Politically speaking, let me pit the left against the right, just so you know how conspiratorial they are against us, how much they both equally hate women, okay? Biden has made clear, under his view, and thus the Democrats' view, sex is mutable, because Biden and the Democrats are very much pro-trans on this question of sex being mutable. Biden has argued that it's mutable. His position on the nature of transgenderism is that sex is mutable. That's their view. But he also says the ERA is valid. Okay? What does Trump say? Day one, when he took office, he issued an executive order declaring sex is immutable. And women cheered. Women cheered, yay, sex is immutable. He's better than Biden. But what else did Trump say? The ERA is not valid. What
Right.
does this show us? What does this show us? We need two factors to get equality. Biden gives us one, denies us the other. Trump gives us one, denies us the other.
Right.
What does this create? A 50-50 divide, making women politically irrelevant because each of them says half of what we need. Bullshit. Yet another way both parties conspire in this dichotomous sense to say to us, doesn't matter. We have rendered you politically useless by making half of you like us because we seem conservative and the other half seem to like us because we seem liberal. No, women hate both of you because you've conspired. This legal setup
Smart women
is
hate
a
both of them.
conspiracy against us, and we will support neither of you. We will all become Alice Paul and vote against both of you monsters until you do the right thing.
Okay.
we have
Hey,
a
wait,
couple
hey,
more
let me just follow up
answers.
Yeah, we
very
have
quickly on that.
Shannon. Looks like we have Shannon.
Yeah, we have Shannon and Fran. And
Um,
I'm
But
not
Pam,
sure
you know
who-
what though? I interrupted
Yeah.
Pam, so will you let her finish, please? I'm sorry about that.
Pam? Yeah. Oh, go ahead.
Oh, who's finishing? I'm sorry.
Pam, I thought you needed to finish.
Oh, I wanted to just say that judging from all the information you're giving us today, this is going to be a real snake pit of a case where you're going to have to walk incredibly fine lines in about 12 different directions. I really wish you luck. And my last question about it is, do you feel, as it sounds to me, like the right wing is going to get heavily involved in your case all of a sudden? They're going to say, we hate the idea of women going into combat. We are against, Bellarmine's case, and they're going to offer
No,
you help.
they've already submitted their brief. They they support women in the military and oppose the ERA.
Oh, you mean
Well,
the
I know
Justice
they oppose the
Department has
military.
already submitted the brief?
Yeah. He sued Biden. He first sued Biden in 2023, and then it switched to Trump. Yeah.
So I'm
Who
talking
is it?
about outfits like Alliance Defending Freedom. I'm talking about outfits that are going to join in, legal outfits that are going to join in this case.
I think it's a tough call left, right on the women in the draft issue, because until 2 years ago, the National Organization for Women supported women in the draft. And then, I don't know if you know this, but there was a bill pending before Congress to change the law so that women would be required to register for selective service, and now supported it. It had been filed over the years, especially during the past 10 years. It had been filed over the years, and in 2022, now withdrew its support. Interesting that it immediately preceded Mr. Valamay's case being filed, right? When they withdrew their support, but they withdrew their support. And I was told, although I'm not sure this is sincere, that they withdrew it in a quid pro quo in exchange for the military changing a policy on how it deals with sexual assault in the military. So they just did one of those little things. But I think there's more to it. I think now withdrew its support because they knew the Valamay case was coming. They were given marching orders, and they were told to rescind their support because everybody, in terms of the powers that be in the moneyed interest, they knew that once Valamay filed and once his case got on the fast track to the Supreme Court, the question would be, what do women do? Do we file our own case, or do we let a men's rights group ask for intermediate scrutiny? And because now withdrew its historic support for women in the draft as just a, equality principle, that's why they had supported it. They withdrew and turned into, a whole new story about how they feel about women in the draft. And lo and behold, Valamay's case went forward without any women saying anything. And yeah, now they won't support us either for the reason that you just described, Pam. But it's strategic and constructed. It's not sincere. It's not because it's a sincere view. It's they got their marching orders.
Well, I'm just pointing out how complex this whole thing could get. My last little thing here is what happens if the Supreme Court decides the ERA isn't valid and makes that holding?
Yes.
I don't think they will because it's too much of a snake pit for them to rule on Article 5 the way that we would require them to. They would rather stick pins in their eyes than answer the very hard constitutional questions about Article 5 and deadlines. So I think that the Valamay case has given them the perfect opportunity to duck the issue by saying we need not decide. We need not decide if the ERA is valid because women only get intermediate scrutiny regardless, and that's because women have now become mutable.
Oh my gosh, I really hate hearing that, but that sounds exactly right. Thank you.
Yeah,
Okay, that's all I have. Thank you so much.
Yeah, okay, so
I
it was
I have a question
Fran
also.
and Shannon, and then Romy had her hand up earlier. I don't know if you still want to, Romy. If you do want to ask another question, put your hand up, and anyone else that hasn't asked a question already. But let's go with Fran.
Okay, a number of things. One is Schlafly's main argument, of course, against the ERA, which got, as we know, tremendous traction at that time, was women will be forced to be in the military, well, along with men. It was also that men will come into women's bathrooms, which is also happening. And of course, the right wing is against that. And I do believe they will be against the draft. I mean, the whole premise of Project 2025 is biblical marriage with totally separate spheres for women and men. So it's hard. It is hard to imagine the Supreme Court going along with that because they are in so many ways an extension of Project 2025 at this point. But I guess what I really want to ask is, okay, what happens in the worst case scenario where they do affirm intermediate scrutiny? Maybe they will invalidate the ERA, maybe they won't. This also could be an opportunity for them to do that if they're so dead set against the ERA. And where do we go then? What do you see as the legal potential at that, legal possibilities for us getting the ERA at that point?
Well, that's a good question, Fran. I mean, I think they're not going to address the ERA's constitutional questions. They just won't. I guarantee you. They don't want to. It opens up too many cans of worms for them. They don't like answering those big constitutional questions. And if they can avoid it, they will. That's just how it is. They're not going to answer. They've got the perfect test case for what they need, which is the ability to say it doesn't matter because women are still only going to get intermediate scrutiny because they've become mutable. That is the perfect setup for them. That appears to me exactly what they'd like to do. Can we irritate them enough to have to maybe do something different? Can we embarrass them into maybe not going in that direction? Possibly, but I guess the point is they don't care what we do. There's no, we don't have any real power. All we can do is shine a light on the cuckoo-ness of it all, right? And that's what I think is worth doing. That's why I think it's worth doing. Sometimes you do a case not to win. You do it because you want to teach people how things work. And that's a minimum what we're going to get out of this. So let's assume the court does what I think, with or without us. Like, let's just say they take Valame's case and not ours. Or even if they take ours and Valame's and they do exactly what I said. They say we don't care if the ERA is valid because women are still only going to get intermediate scrutiny because under Scrimeti, sex is mutable, period, end of discussion, end of, we're all done. In one sense, it makes me think in terms of what do we do in the future? If they've just declared that we only get intermediate scrutiny, regardless of what the Constitution says, we don't really have a remedy for that. Because I suppose someone could say, well, let's amend the Constitution to say mutability cannot be the determining factor for strict scrutiny. We could do that. That's not quite an ERA. It's just a declaration in a constitutional way that mutability cannot be the decisive factor. And then it could get us back on track for revisiting the question of equality regardless of mutability. But keep in mind that my key argument here on mutability is going to involve a lot of the scholarly stuff that's already out there that has argued for years and years and years that not only is this hierarchy of scrutinies ridiculous and anti-democratic and really offensive. I mean, it's just really bad to have a hierarchy where some people have better rights than others. It's craziness. But also it's craziness to have mutability be the thing that determines whether you're entitled to equal treatment. Because what does that have to do with whether you're worthy of equal treatment? I mean, so I'm going to have both of those arguments in my brief. How dare you overvalue mutability? How dare you have a hierarchy in the law that says some people are equal and some aren't? What country is this? Like, those are two arguments we're going to be making. And if the court chooses to disregard them, then we take those kinds of arguments and find a different constitutional amendment to repair the horrendous decision the court makes that embraces and validates those two ideas. Because it's obscene, but it could happen. And then I think we just don't have an ERA anymore. We have an amendment that is tailored to the absurdity.
Wendy, you had said in a speech that moved me very much sometime during the lead up to the Biden statement when there was so much activism going on, and you made a speech, I think it was something that Jean Sweeney and others were there at, basically saying if the court rejects ERA outright, women, we will rise up. That is our shot at women rising up, which was actually the basis of my first question to you. Is this a women will rise up kind of case, which is something that has really mulled over and bothers me. Okay, so yeah, where do we go in terms of women rising up? Are you just playing it by ear and saying we'll go somewhere? Because it seems it would be determinative if they do say that we get intermediate scrutiny and we are mutable. Those are two things that's going to be much harder to fight at that point. Yep. So are there other cases that women might rise up over that involve is the ERA dead in the water? I guess that is really my question at this point.
It's not dead. It's not dead. It's immobilized. Yeah, nullified. It becomes irrelevant. If they do what I fear they're doing, it's going to become irrelevant. It just doesn't matter if it's valid. And that is the meanest but most effective way to destroy women's rights without provoking us to rise up. Because without a substantive ruling saying we hereby declare that the ERA is shit and it's not valid, we rise up because we're angry about the ruling. And if they, so they don't want to provoke us to rise up. Therefore, ruling that it's irrelevant is a softer blow.
A softer blow.
It's a softer blow, yeah. And it also totally changes our strategy. For the past 100 years, we've been pushing for this one thing. We can't push for that thing anymore. We got to have a new thing. we can have a new thing and we will have a new thing, but it's going to be a whole new thing.
It's going to be a whole new thing. I also just want to end my question by saying that I am very attached to the idea that women are a sex class, an idea that connects us to the guts of the left, right, as radical feminists, and very important in terms of arguing everything from against the transgender ideology to just everything else. So it seems to me that that women are an immutable class goes with women are a sex class. And where do you stand on that? Because I would definitely want to defend that argument no matter what happens.
I think the best answer to the question, are women immutable, is to say, yes, women are immutable, absolutely, because race is immutable. I always tether sex to race.
Race is more mutable than sex.
Exactly.
Yes.
But I tether my arguments about sex to race all the time because treating race better in terms of having a better level of scrutiny is irrational. And when you try to make people explain, like in the UK, again, I'm going to harken back to the UK, they don't have a constitution, so they don't have the problem in the way that we have the problem, but they do have intermediate scrutiny for women in their Supreme Court decision making. So if you really look at the nature of their problem there for women, it's equally difficult to see, but the point is to always compare it to race. So if you had a systematic race-based discriminatory practice of some sort by the government, let's say the government disproportionately failed to prosecute people who beat up Black people, right? Like, let's just say they showed that every time a white person kills a Black person, they don't get charged. When you go to court to complain about that as an act of the government that is discriminatory, that gets reviewed under strict scrutiny in the UK. If you made exactly that same claim about police in the UK, about police disproportionately never filing charges when a woman is killed, they'd be more likely to get away with it because the scrutiny they impose is lesser. It's akin to intermediate. They even sort of use that language, intermediate. So I guess my point is that it's almost regardless of immutability because we now have a new UK Supreme Court ruling from a couple of weeks ago. I'm sure many of you have seen it, where all the sex-based class people, I'm saying that the wrong way, all the sex class people were so happy. Yay, we're so happy. Because the Supreme Court said sex is its own thing and gender ID is a different thing, right? They did that separation and they did a lot of discussion, and it's like a 65-page decision. It's very long, very cumbersome, and the gist of it is you can't change sex. So they kind of won the immutability argument there, but they don't have the mutability problem that we have. So keep that in mind in terms of this question of intermediate scrutiny. But why am I saying this? Because despite the Supreme Court of the UK ruling that sex is immutable in a decision everybody cheered for, women are still subject to intermediate scrutiny. They also have an Equality Act there, and they cheer for it because it looks like it's good for them, especially now that they have this ruling about sex being different than gender. Well, it doesn't matter. They still have only intermediate scrutiny. So this is what I'm trying to impart to you, this knowledge of really grasping it's a fiction. This idea that mutability matters is a fiction, but it is a nice fiction for a court that needs a hook upon which it can hang its outrageous ruling that women are still only entitled to intermediate scrutiny in the United States because they have become mutable. It's not a real reason. It's a completely fictionalized, made-up justification for perpetuating our subjugation.
Okay.
So I don't want to get lost in the weeds on sex versus gender, mutability, bathrooms. I'm not going down that path because I'm going to argue that no class of people should be subjugated and subjected to intermediate scrutiny. And in that sense, we may become an appealing lawsuit to a wider swath of people People who are interested in conflating hierarchies will become our friends. People who think inequality because of who you are is just wrong. Those won't necessarily be women. They won't be gender ID. They will be human beings who see the value of collapsing hierarchies. Those are our allies. And that is going to be our position.
Thank you.
Okay, Wendy, we're getting close to the end here, and we have three more people that would like to ask questions. And I believe Shannon was first. We'll need to kind of go a little quicker pace here with the questions, but go ahead, Shannon. And go ahead and unmute.
Sorry, my phone decided to go wonky. I'm not sure what kind of, if we need even deal with trying to get legislative support, but I know I've been disappointed with Warren on the trans stuff, but she does have a feel for the women and the economic BS, and she is technically reachable with town halls and stuff. Would it be a thought to try and reach her in
Elizabeth
Massachusetts?
Warren has never done anything for women, not for women's
Damn it.
equality. No.
Damn
No,
it.
she's useless. I'm not saying she's useless on everything. She's useless on women's
Right.
equality. Absolutely useless.
Yeah,
Oh,
she
that
had,
sucks.
well,
I knew she
But thank
wasn't
you.
good on the trans, but I was hoping at least she's working with women. Yeah. Okay.
yeah.
Thank you.
Okay, thank you, Shannon. Kathy, you want to go next, and then Romy.
Sure. So I have two questions. So I'll give you the questions first because maybe they'll connect somehow. One is around immutability. So if sex is immutable, that should affect men. It's not just about women. If men can change their sex, then why would they still get strict scrutiny? Number one. How does that play out? And the second is, what kind of strategies could be used to get judges and lawyers to use strict scrutiny when they're not asked?
Yeah, those are such good questions, Kathy. The men and sex question is, I often get that. And the short answer, I'm going to be as short as I can. It's potentially a much longer answer, but the short answer is men were never excluded from the Constitution. So they're not crawling back. They don't need any scrutiny because we were excluded. So we started off at 0 with non-personhood. We got bumped up to a little bit of personhood. Now we're in this middle second class place, but men were never not there. So they're still not climbing up. And
But we can't bump them down either.
no, and I wouldn't argue to bump anybody down.
I know, but I just
Some of us
saying,
might.
if they thought they could be bumped down to get lesser scrutiny because of immutability, it might be.
They don't care. They don't care because
They
they don't care at all about women's equality fight. They have never needed it.
Yeah.
It's not that men never suffer discrimination and or are subject to intermediate scrutiny. It's that it's not a systemic problem because they were never 0 to begin with. So that, the constitutional gap has never been about them. And that doesn't mean men don't suffer discrimination. It's just not the issue. It's sort of like, well, don't we want to protect white people who wear cornrows? Well, not really. Okay, it's kind of a white people can wear cornrows, but it's really not a white person's problem. And what was the second question?
What kind of strategies could encourage judges and lawyers to use strict scrutiny without being asked?
So I and my students last year started a project called the Strict Scrutiny Project. What we've been doing, although it's hard, students are always so up and down, and it's not an easy category of law to focus on. Most lawyers never deal with scrutiny, and when they do, they go, oh my God, I'm having a flashback to law school, because it just isn't in the practice of most lawyers. So my students get overwhelmed, but what we've done is develop a project where our plan, and we've done a little bit of this, is to file amicus briefs in every case where we can get our hands on it, where we can find out about it, where a lawyer has sued and asked for intermediate and it's a women's rights case. And our goal is to file what is like a canned brief, a canned amicus brief that we can cut and paste and just file in every court we can get our hands on, saying, no, we object. We want strict scrutiny, and also to some extent use the amicus brief opportunity to try to urge the lawyers themselves in the case to ask for strict scrutiny, because again, we're trained to only apply that which is the law, not which ought to be. So sometimes I'll talk to a lawyer and say, why did you ask for intermediate scrutiny? Their answer is, well, that's the law. And I say, yeah, but why don't you just ask for strict scrutiny and say, you know, the time has come for strict scrutiny. And then in the alternative, and if you don't agree with that, then we'll take intermediate. And sometimes the lawyer will go, oh yeah, you know, I never thought of that. So it's an education thing as well. But what I'm trying to say is we did exactly this, and EME was involved, and the Elizabeth Cady Stanton Trust was involved. I wrote amicus briefs in 2 of the abortion rights cases after Dobbs, where they were, as you may remember, there were lots of cases filed around the country at state court level trying to argue that the state constitution protected abortion rights, even though Dobbs had destroyed abortion rights. And I was filing amicus briefs, like slamming the lawyers for asking for intermediate scrutiny, because the doctrine under which they were seeking to protect abortion rights under the state constitution was the equivalent of the 14th Amendment. So the state constitutional version of the 14th Amendment Equal Protection Clause was the focus of their argument. And they're saying, you know, uphold abortion rights under the Equal Protection Clause for women under the state constitution and apply intermediate scrutiny. And I was writing amicus brief saying, no, I object. Who the hell asks for intermediate scrutiny under the state constitution? Under the state constitution, you absolutely should be asking for strict scrutiny, because it's only the federal constitution that even says intermediate is the standard. And I'm a little bit misstating it, because there are some state appellate court decisions that do apply intermediate scrutiny to women's equal protection claims under the state constitution. But a perfect example is in Texas. We had all this stuff going on in Texas. Texas has a state constitution. Now listen to this, you won't even believe this. Texas,
Oh, I know. I live there. I know.
no, yeah, but listen, you're going to freak out when I tell you this. Texas has a state constitution with an equal protection clause. The Texas Supreme Court in the 1980s gave women strict scrutiny under the Texas state constitutional equal protection clause. Women have strict scrutiny in Texas. When I was watching their litigation around abortion rights, I read the briefs of the Planned Parenthood people, the ACLU, the Center for Reproductive Rights. They all asked for intermediate scrutiny or worse. And so I filed a brief down there.
And that's because they're all captured by gender ideology.
Well, it's not just that. It's that they're all funded by porn. I mean, let's get to the bottom line. It's always about money. But what I'm trying to say is, I found a lawyer to help file this for me, and he said, I don't understand why they're not asking for strict scrutiny. That's the law in Texas, strict scrutiny. I said, well, yes, will you enlighten me? Like, what do you think? And he said, I have no idea. The case law is clear. Women have had strict scrutiny under the such and such case. Let's say it was the McDonald case. I read all of their briefs. They didn't cite the McDonald case once. So in my amicus brief, I wrote a whole section called, why is nobody citing the McDonald case, you know? So I cite the McDonald case and say, you have to apply strict scrutiny. This is mandatory, blah, 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 blah. The Supreme Court completely ignored everything I wrote. Completely, just pretended I never filed it. It was filed, it's on the docket. You can see it if you go look at it. This is the downside of amicus briefs. I'm 100% right, and they can 100% ignore me.
And
Yeah,
where can I find that? Where can I find that brief? At the text at
Did
the
in
text?
the chat. Both of the Texas cases are in the chat.
Yes, I filed, and I filed on behalf of EME, and they have them all at their website.
Oh, thank you.
yeah.
Looks like we have one more speaker, Romy.
Yeah, Romy, go ahead. Oh, unmute.
Romy, you're muted.
Yeah, you have to unmute
There
yourself.
you
There
go.
you go.
Kathy kind of anticipated what I was going to say, but okay, if the immutability is kind of like a barrier or like a barrier in the stomach where certain things can go through, and now they're permeable. Now, why can't women who are trans demand strict scrutiny as men because they've transitioned and become? Am I clear in thinking?
Men don't get strict scrutiny, Romy. No, men don't get strict
They don't
scrutiny.
need it.
They just don't need it because they were never subjugated.
Yeah, so, yeah, Jean, did you want to add something?
But by the way, all trans people can ask for strict scrutiny, but the big firms that represent them, the ACLU and all the, anti-equality money that funds them, they only ask for intermediate. And I think that's malpractice on their behalf.
Jean, did you want to mention something?
So Wendy, the other day I was thinking, okay, so I grew up in Scarsdale, and in Scarsdale they had a town ruling that nobody was allowed to run on the streets topless. That included men and women. So now in Connecticut, I think in my town, that women are not allowed to be topless, but men are. So now I'm thinking, okay, so what if you have a trans identifying man who's had, breast implants and everything, and he's running through the town of Darien topless? And what do the courts do with that?
That's actually such an interesting case, and I've thought a lot about that over the years because it struck me as an opportunity to really get a good ERA case in front of the courts. But there are a couple of problems. One is obvious that, and the court has talked about, the Supreme Court has talked about this in terms of creating the legal contest between the other. So often the court will say, well, you can't just have one group complaining about discrimination because the other group is treated differently, and yet the real battle is not that they're treated differently, it's that they are different. So for example, on the abortion case in Dobbs, Justice Alito was writing about how you can't have discrimination based on pregnancy that is sex-based because men can't get pregnant. And because men can't get pregnant, you can't discriminate against women in how you treat them with regard to pregnancy because you don't have a comparative class. That's the kind of thing they would do with this breast issue, exposure of the breasts. They would, number one, use definitional terms to explain how it doesn't change much because you're still talking about breasts, whether they're born into the body or added, it's still breasts. So it's breasts versus non-breasts, right? And the question is not what are the other body parts? It's like, are there breasts? So they would then say, in the way that they did with Dobbs, you have no discrimination claim because yes, it's generally women who have breasts and men don't, but because you don't have a comparative class, it's different treatment, but it's not discriminatory treatment. The court does that a lot with women's issues, even though that's not a consistent theme behind how they differentiate, for example, based on race. Because this came up as an argument. I'll bring up the cornrows issue again. When Black children suffer discrimination because they wear cornrows and they go to court to complain about it because the teacher, made them leave or something. One argument to push back is often, well, the white children can't wear cornrows either. So, okay, but that's not really the comparison because it isn't about cornrows, it's about Black culture. So they'll often take a step back and say, well, it isn't really about if you're transgender or you started as a female or you cut yours off or you added yours on, it's about the visibility of the breast. They'll find a way to say there's no comparator, if you know what I'm saying. It's another fiction in law. used to deprive women of the profoundly obvious argument, which is that the fact that they can become pregnant is itself the basis for a discrimination claim. The fact that they have sex parts that become pregnant should give them priority standing anytime they argue that they were treated differently and worse because they were pregnant. But to accommodate women and still keep the law weak for women, they created a whole different thing called the Pregnancy Discrimination Act, which took it outside the constitutional space. And now if you have pregnancy discrimination, you go through a very different kind of legal analysis that isn't really constitutional the way that it should be. In the same way abortion should be, if you ask me.
Well, thank you. But it's something to think about.
Yeah. Oh, I'm always interested in finding ways to file claims, but I don't want to waste my time filing
well, we'll
about
figure it
breasts.
out.
Yeah,
Yeah.
if you file about breasts and the court says, that doesn't fit the definition of discrimination, you've just wasted all your energy. So the lawmakers and courts have made it really hard for women to come up with cases where they can make a really smooth, clear challenge about discrimination. When we filed after the ERA cases failed, when we filed claims in the state case claims in Rhode Island and New York and in Michigan, the way we found examples of problematic laws was we basically went back to the 1800s and found, or the early 1900s, like New York had a law where if a woman wanted to open her own laundry business in her house, she didn't have to go through the health code. But if a man did, he had to. And the reason they
That
differentiated.
seems pretty rational to me, given the way.
Well, but men were off at war and the women were impoverished. So they made this special category so they could earn a living without going through the hoops and hurdles, but it's still on the books, right? So it's absurd. Why should women be able to have a laundry business but not go through the health code, but men have to go through the health code? That is a discriminatory law we could sue over, but we would have it dismissed because it doesn't apply anymore. It's on the books, but nobody uses it anymore.
Yeah. Okay. Well, this has been a wonderful discussion. We're about 8 minutes over our 2-hour time. Fran, do you have a really quick question you want to ask, or do you want to make a comment maybe? I see your hand up. I don't know if that's maybe.
Fran, if you're trying to speak, you're muted.
Yeah.
Yeah. Okay. I'm not muted now. Okay. Trump just offered motherhood medals to women. Okay. You've probably been following that. Okay. And I researched that, just did a show on it. What's very interesting is that in countries where there were motherhood medals given to women, they're all fascist countries, of course, having 8 or 9 children, they were military style medals. They had the cross, the Croix d'honneur, right? They were based on, and Hitler actually said, the men show their courage on the battlefield and the women show their courage by having all these children. But what it was a way of giving women an equality with, in terms of serving the country, right? By having all these children with being in the military. And I just think that is exactly what we're trying to take down here. That's those separate spheres. So if you get my point, I don't want to belabor it too much, but if I'm sort of ending with a very pro argument for the case, Wendy, because I'm saying that there apparently is this need for women to have this recognition that we contribute on a military, on fighting for our country basis. And that's what those motherhood models were all about. Of course, it was also keeping us in our sphere, et cetera. But that is, a great kind of, even the terrible countries have a need to give us something in that way, because it does confer so much status to be in the military. So I want to end on that note.
That's so funny.
Okay. All right. Very good. I just wanted to mention here that anybody that would like to consider looking at the stuff on EME, we have several interesting things that Kamala has posted here, as well as just the EME website, which I think everybody pretty much on here is familiar with. but also I wanted to, I wanted to invite Kathy. Would you like to put the link in here to the unabridged Constitution, U.S. Constitution, that you know, the one to the PDF, so everybody can get a copy of that?
It's gonna take me a while to get it, to get you
Okay.
one. I don't have it
Okay.
ready, you know, so. if you-
Okay.
So let me
Does
see.
anybody else have that handy? Jean, do you have that handy? Do you want to share it?
Let me see. I'm not sure.
I'm on this computer and I'm not sure that it's a new computer and I don't think I have it on this one. I have it on my old one.
Carol, can I just very quickly add that I put in the chat the information for Joy of Resistance, the feminist program that I do on WBAI. So I hope people will look at that link.
Right, yeah.
Thank you.
We do have it posted, Dina, on the FIST website. So, and by the way, there's a lot of good information on our website, including those feminist amendments to the Equality Act that we spoke of earlier, and that's at feministstruggle.org. And I'll put that in here. Is there anything else that anyone else would like to share on the chat? Because you know, because people can make a copy of the chat and keep this information, which I'm going to do here
If
in
I
a
can just
minute.
add, Carol, that we encourage women to join Feminists in Struggle. We're always looking for new members. We're
Yes.
membership run and trying to build local chapters. And so we would love to have you join us.
Yeah, that was going to be my latest plug too. So thank you all so much for being here. Thank you to our wonderful three speakers and all of you that participated. You really added a lot to it by your great questions and comments. So we're going to go ahead and stop the recording now, right, Anne? And then we'll end the call.
Carol, I just put the
Thank
link
you.
in the chat.
Oh, you found it. All right, wonderful.
Mhm.
So yeah, you can copy that chat, of course, up in that
second to do that.
upper right hand. Those three dots should allow you to save the chat.
Thanks. And
So,
I'm going to upload this on our YouTube channel, and underneath in the notes for the show, I'll put all the links. Carol, if you want to send them to me in an email, I'll put them all in the notes for the recording. Thank you, everybody.
And
all right.
sorry, one more second. Sorry, I just you all know I'm part of Here She, but we work on also creating a letter campaign that has like a form letter with the information, and then we add a personalized letter. So if we want to bring attention, I like to do it where like the mail arrives all on the same day if it's someone specific we're hitting, you know, stuff like that from all over the world, or to individual voters or people we're trying to reach. So if you have an idea that we can raise awareness or someone we need to hit with 400 letters,
Right, right. Like
let
about
me
the SAVE
know.
Act, for instance.
What's that?
Like about the SAVE Act, that we need to make sure that it gets defeated in the Senate because it's going to disenfranchise millions of women. But that, yeah,
Right.
Shannon does a wonderful email where she includes all these different issues in her email. But go ahead and finish.
Can I say, wait, let me say one quick thing about the SAVE Act. I don't want to forget. The reason the SAVE Act, you're talking about women who, the married name issue?
Yes.
Yeah. Just emphasize, if you're going to send letters about that if the ERA were valid, if women had strict scrutiny, if women had full equality under the Constitution, the SAVE Act would be illegal. Point that out.
Oh, that's a great point. Yeah, thank you, Wendy. Okay, excellent. Shannon, do you want to put your email in the chat by any chance?
I think I put it in there twice.
Oh, okay.
So,
all right.
yeah,
great.
yeah.
Okay,
And especially like even press, right? If they get 400 letters from different people with handwritten envelopes that are opened all on the same day, that puts a pressure on the press to pay attention. So there's just a few strategies that we use. So we'd love to do it for sure.
Excellent. So thank you all again. It's a wonderful presentation. Thanks.
Thank you, Carol.
Excellent.
So,
Thank you, Carol, for getting us together.
yeah, thank you. We'll close it out now.
Have a nice
Dan.
rest of your weekend.
Yeah, you too, all of you. Hope you have a great weekend. Take care.
Happy Mother's Day.
Yeah, happy Mother's Day, whether you're a mother or not.
Well, they gave us that when we were looking for the vote, and they gave us that instead. Just a quick comment.
Oh, thanks, Fran.
Not that we shouldn't enjoy it.
My goodness. Never ends, does it?